Hi, good morning. I'm coming in briefly this morning to update and put in context an important case that comes up before the Supreme Court. The Prashant Bhushan case, where the apex court held him guilty of contempt of court, and today a hearing on the quantum of punishment will be held. That charge carries a maximum punishment of up to 6 months imprisonment or a fine of 2,000 rupees or both. Now, why is this important? Number one, as it takes a final call in this case, all are going to be extremely conscious that anything the Supreme Court does becomes a precedent, especially for high courts when it comes to contempt proceedings or, for that matter, criticism of the judiciary in the future. Let me give you a brief context if you've missed this story. The Supreme Court held Advocate Prashant Bhushan guilty of contempt of court for 2 tweets, which have since then been withheld by Twitter. In the first tweet, which included a photograph of the Chief Justice on a motorcycle, Mr. Bhushan was held guilty of making a knowingly false statement about the denial of citizens' right to access justice. The second tweet was critical of the role allegedly played by the judiciary and the last 4 Chief Justices. The court, in its 108-page judgment, found that the tweets undermine the dignity and authority of the institution. In fact, the court also observed that this could have an effect in ordinary litigants losing confidence in the court, as also impacting the confidence of other judges. And I'm paraphrasing here. Now, Mr. Bhushan's submission was that this was his opinion, and however outspoken or disagreeable it may be, it cannot constitute contempt of court. Now, we're obviously well past that stage, because the highest court did not find Mr. Bhushan's submission or his argument worthy. In the last couple of days, there have been many who have spoken for him: former justices, activists, the Bar Association, public intellectuals. One of the most interesting pieces I read was an op-ed in the Indian Express. "All Guilty as Charged" was the title, where the author, who's a senior advocate, guided us towards the significance of this verdict. Number one, he said, did it merit disposal during a pandemic when matters of far greater importance were pending? Let's say challenges to Article 370, electoral bonds, habeas corpus petitions, etc. He also argues that the significance is not that Mr. Prashant Bhushan has been found guilty, but that a test has been applied. And the test is broadly this: that if the words or conduct shake the confidence of the public in the judiciary, the same can constitute contempt. So every criticism, some would say, no matter how measured or how responsible it is, will always, in that sense, affect the public's confidence. So in some ways, we're all guilty as charged. Now, it's judicial wisdom alone that will decide the quantum of punishment today for Mr. Bhushan under what many call an archaic legislation first enacted in 1926 with origins in British law. And we'll bring you those updates as they come. But before I go, remember not too long ago, Justice C.S. Karnan was sent to jail for 6 months for calling out the names of allegedly corrupt judges in a letter to the Prime Minister. He spent the full 6 months in jail under the same charge. The top court, in fact, barred the media from publishing or broadcasting Justice Karnan's statements. I don't remember hearing that much outrage then. Now, Mr. Bhushan was one of those who welcomed the imprisonment of Justice Karnan. Not suggesting anything here, but that's all we have for in this video. It was an important story, so we thought we'll bring you up to date. If you've been watching, thank you for your time.